Okay.
Welcome all. I'm Tony Goujon with the Community Networks of Specialized Care, and I'm happy today to welcome Kenneth Pope to share some valuable estate planning information. Mr. Pope has practiced law in Ontario since 1980 and offers specialized support to individuals with disabilities and their families. He is very knowledgeable and experienced in this particular area, and today's session will likely have something for everyone joining in. Some quick housekeeping. Please keep your microphones muted unless you have a question for Mr. Pope. And for those joining via webcast, I've just been informed that OTN has enabled the little, there's a speech bubble on your screen that you can click to send a question directly in. Alternatively, the email address that's on the screen right now, you could send an email directly that way if you prefer. So with that, I'll thank you all for tuning in and turn it over to Mr. Pope.
Thanks, Tony. I appreciate that. Good morning, everyone. Glad you could take part. My law practice specializes in wills and trusts and tax issues and ODSP problems for families who have kids with special needs. It's a provincial and interprovincial practice. I've been doing this particular work since 1996. We've had an opportunity to work with a number of families across the province and around the world, actually. And the discussion today will cover about a dozen topics. I'll use a few stories to explain a few things, and you should feel free to send in questions, either to the email address that's displayed on the screen, or using the Ask a Question function with the OTN webcast facility. I'd like to know actually where those questions would go so I can see where they're going to go. Tony, where would those questions go? Would they pop up on the screen for me too?
No, they also come into the same email address that's on the screen.
Ah, fine. Excellent. Perfect. That's great. So, there are at least 100 people registered for this webcast, plus OTN sites around the province. We'll get the numbers back on that afterwards. But I sent an email to my newsletter list, which has about 5,000 people, families, support organizations on it. And it was on Tuesday morning at 8. And we've had a phenomenal response ever since. The email just keeps coming in with people registering. And of the people that have registered, about half again can't take part today, but they want the link afterwards when it's archived on my website. So of course we will be sending that to them. If people have any follow-up questions that you would like to ask, you're welcome to call the office, or of course, as I say, to send email questions today or afterwards, and we'll be happy to respond as best we can. Of the people who attend my seminars, whether it's an on-site seminar or a seminar like this, I keep track statistically, and what is a consistent truth is that of the people that attend the seminars, not the people who do not attend, and of course the people attending know that they need a will with a Henson Trust, right? The profile for Henson Trusts, I've worked diligently since 1996 try to raise the profile of the awareness of the need for Henson Trusts. 50% of the people that come to these seminars have a will, but a very, very small number, even today, have a Henson Trust. And 50% don't have a will. I remember a seminar I did one time in Kingston at the library. It was a Saturday morning, and was setting up at about 10 o'clock. And there were 15 people who were there early waiting for the seminar. And I was surprised because of the 15, 14 had wills and 1 didn't, which is statistically, I mean, it's a small test group, but still, that's very unusual. So about 10:10, we're just getting started, and another 15 people come into the room because they've been down the hall in the wrong room, and when I collected their information, 14 didn't have wills and 1 did. So it rounded itself out very quickly. But when you stop and think about it, in the province, that's a lot of people who don't have wills. And of the people who do have wills, who have kids with special needs, it's still a relatively small number that have Henson trusts. So the job remains to raise awareness, and then also not just to raise awareness. You know, lots of organizations raise awareness. What I'm more particularly interested in is raising awareness and then actually delivering the service so that people have their affairs in order. I find that it leads to peace of mind, and we do about 12 different things for families with special needs. We quite often do 2 or 3 of them right at the start. So for example, people may not start with doing their wills. They might start, for example, with powers of attorney for their child, because now the child is a young adult. The parents are concerned that they might not get the same kind of cooperation that they got before from hospitals and doctors, because now there's privacy issues and so on. And so we then have a discussion about powers of attorney from the child to the parents. So for those of you who have adult children who are competent, we should have powers of attorney from the child to you so that you can access information and help to handle their affairs. If a child is an adult and not competent, of course there's a whole discussion around competence, then you then start to look at legal guardianship. Of course that's a more legal, expensive process, so I don't advise it unless it's going to solve some problem that you have. But the discussion of competency is part of most estate planning arrangements. As far as the question of, is my child competent to sign a power of attorney, there are levels of competence, but they're not just straight bars, such that although the highest level of competence that's required is, for example, to do a will, you may well have a child who has an RDSP, and of course we'll get into that in a moment. So he has assets, because of course the RDSP is the child's asset. Well, are they competent to do a will? And if they're not competent, well then what happens to the RDSP if they should die? So this whole competency issue starts out with powers of attorney and then goes further these days. The test for competence is if you have on an axis, on a vertical axis, let's say x-axis, and on a y-axis, if the cognitive ability of the child is sufficient to meet the complexity of the issue of whatever's happening, well then competency is function specific. It's not just, oh well, he doesn't meet this bar. If he meets this bar sufficiently for the complexity of the situation, then that's competence, sufficient competence. And in a further case, if the child knows and has insight, for example, into the fact that he understands many things, but doesn't really fully appreciate the likely effect of certain actions. But he, for example, he knows that he would need some assistance with handling his affairs or making decisions, but that he knows who it is he wants to help him with those things. Well, then you start to get into a situation where he's competent to understand his circumstances, and he knows who it is he would like to assist him. And so then you get into a situation where the child is probably competent to sign powers of attorney to appoint his parents, for example, to handle his affairs. Although he himself may be, for example, innumerate and couldn't make change. So it's a very interesting discussion. If you have any questions about that, send me an email and I'll be happy to respond. Now the purpose of a will with a Henson trust, because I know most people have a lot of interest in this, is to have a trust to receive an inheritance, a share of an estate, life insurance proceeds, to help provide for a child when the parents are gone. And there's at least two factors. And one is that the child quite typically couldn't handle the money if they did inherit it directly. So you need a trust arrangement and trustees to receive this inheritance and manage it for the child, because they couldn't handle it themselves, so they would lose it. And then secondly, of course, a critical factor is that such an inheritance over $5,000, for example, simplistically, would disqualify the child from ODSP. And of course, this isn't exactly what the parents had in mind, that at the very time that the parents have gone and the lifelong advocates for the child have gone, that the child comes into money, which then disqualifies them from benefits. So what you need is a Henson trust. A Henson trust is named after Mr. Henson, who died in Guelph back in '85. And he had left about $82,000 for his daughter Audrey. And when in this particular way, and the provision was that when Audrey died, that the Guelph Association for the Mentally Retarded, as it then was, would get what was left. So when the ministry heard about this inheritance, they said, well, there's Audrey's inheritance. Have her use that, and when it's gone, come and see us. So of course what this meant, or would have meant, is that the inheritance would have been exhausted. So it went through effectively an ODSP. It was under different guidelines and regulations at the time, but basically an ODSP, Social Benefit Tribunal appeal, where the tribunal officer agreed that given the wording of the trust, that it shouldn't disqualify Audrey from benefits. So then what happened was the ministry, having finished this administrative appeal, which is a necessity for the next step, took this to a judge, to court, to ask the judge to determine that the terms of the trust should disqualify Audrey from benefits, but the judge disagreed. And he felt that the decision of the adjudicator at the tribunal was correct. And so what this did was it meant that that judge's decision is binding on all cases where there is a true, properly drawn Henson trust. And that was great. That was as of the fall of '89. So it's been quite a while. And as I say, there's a high profile. People know the term Henson trust. But to a large extent, the reason I got into this practice was because back in '96, even then, people didn't know what they needed, and if they did know what they needed, they didn't know where to get it. So I thought, well, that's an interesting fact. And so I built my practice from there. But things are still still growing. There's no shortage of clients who need assistance. So that's wills and trusts. I won't go into the process to set up the Henson Trust or how it's administered and how it relates to ODSP just now. Excuse me. But if I have time, I will later. I suppose you're wondering how much Tim Hortons paid me to position this cup in this webcast. It was a lot of money. I haven't received any questions yet, so I'll just carry on. Now, when a child is under 18, they may well qualify for what's called Assistance for Children with Severe Disabilities. And it doesn't really turn on the severity of a disability. What it turns on is that the child has a disability and the parent's household income is low. But it's not so low that it wouldn't catch a whole lot of people. A lot of single moms, for example, specifically, their household would qualify. So if you happen to know a single income parent household with a child with special needs, which is not unusual, then you should let them know about Assistance for Children with Severe Disabilities. You apply for this through the ODSP office, standard ODSP office, and it's several $100s a month, potentially. It's based upon real need. You have to establish that there are certain expenses, costs that are, that you can't carry, you can't meet. But it would cover respite, and it would cover a number of disability-related expenses that you may either be paying for now or just can't afford. Then once a child turns 18, of course they qualify for ODSP proper, and it comes in two different amounts. If the child is at home with you, which they would typically be when they're first 18, then the child would automatically be slotted into room and board. The room and board amount is, what is it, $842 now? $841. And so the child is slotted into $841 on the basis that the parent provides the room and food, which of course they do. The second amount, which we often can get increased, is $1,098, which is shelter plus supplementary. And the shelter plus supplementary obviously includes a shelter cost, which if a child, for example, was in their own apartment, they would be paying rent. So the shelter component of the $1,098 is, I believe, $498, just shy of $500, which, regardless of how much they pay for shelter, that's what they get. Of course, if there's any higher costs, then of course somebody else has to cover the difference. But we regularly get these benefits increased for the child, the family, where the child is at home living with the parents. Approximately 15% of people on ODSP, 18 and over, reside with family, parents, siblings, basically forever. They may well reside with their parents, of course, until the parents die. And then, of course, there's this big transition. So that may or may not be the best process to basically wait for the parents to pass on. But we are quite regularly able to increase the $841 to $1,098. What we do is we set up a lease between the parent and the child pays rent. Now this, quote, rental amount is not in fact rent for revenue, Canada Revenue Agency purposes. Because, and of course we send along material about why this is not rental income to be declared to the client families. The short story is that if you're not in pursuit of profit, then you don't include it as rental income. And of course, if your child is living with you and they're contributing, quote, rent, shelter costs of $500 a month, you're clearly not, pursuing them to make a profit, and so therefore you don't include it as rent. The child also can't use the tenant property tax credit because, of course, they're not really paying rent, so they can't do that. Are there any questions about that? Now that's a good thing. To get benefits increased is always a good thing. If the child was simply unable to shop or cook at all, then we might not be able to do this. If the child was being fed with a G-tube, a gastro tube, well then they would qualify because the parents are not providing the food. And if someone prepared the food for them, for example, there's a woman in town here who is a roving chef, and if you pay for the groceries, she'll come in and she'll cook for, I think it's approximately $250. She'll cook 4 different meals and four portions, so like 16 dinners, which would then be put in the freezer, because a lot of the kids, of course, can certainly microwave things. And if you had somebody come in to prepare the food and then set it aside for the child to prepare to eat as they wish, well then that would qualify. It's only if the parents are providing the food that the room and board amount is properly applicable, and if there's no way around it. One of the first things that we do, one of these several things that we do before clients necessarily proceed with their wills and trusts, is we get the benefits increased if we can, and then we see whether the parents are making use of the disability and the caregiver tax credits. Now, the disability credit is the child's credit. There are, I would say, about 600,000 people in Canada who are presently approved for the disability credit. And what it turns on is whether the child is markedly restricted in some way, or takes substantially longer to do certain things, activities of daily living, or if they are severely restricted in at least 2 of 7. So it may be that the child is not markedly restricted in one way, but is severely restricted in a couple, which is equivalent to markedly in 1. That's been since 2005, so it's been a while now. Now, the most common scenario that we find is that the credit should be used. You know, when you look at it rationally, the child should be qualified, should be approved for this credit, but they're not, or they used to be, but the family let it lapse. And we then put the credit back in place, and we backfile it. Typically, the most common file is we backfile it for 10 years, because you can go back 10 years under what are called the fairness provisions. And the recapture for an adult child for that 10-year period, the recapture, the recouping of taxes paid by the parent, for example, because the credit is transferred from the child to the parent, the tax-paying parent. It's of no use to the child directly because they don't pay tax. The recapture is about $16,000. Now, if it happens to be a child under 18, then the recapture is greater. The recapture is about $22,000. If the child is under 18 and is approved for the disability credit, then in addition to the Canada Child Benefit, and I appreciate that things may have just changed a little bit with the new baby bonus money that's been shipped out. The standard child benefits that are received by the family are supplemented if the child qualifies for the disability credit by the Canada Disability Child Benefit, which is a maximum of about $250 a month, about $2,500 a year, subject to household income. So if the income is as high as $150,000, then there's no credit left. There's no benefit to be received. This is unlike the Canada Child Benefit, which is tested up to $75,000. So it wouldn't be uncommon to find a household where they just simply haven't applied for the Canada Child Benefit. Thank you. Because they know the household income is greater than $75,000. You have to have applied for the Canada Child Benefit, for which you don't receive anything, in order to get the Canada Disability Child Benefit, for which you would, because the household income is tested up to $150,000. And of course, this can be done retroactively as well. I remember a file family in Maple, Ontario, and there was a son and a daughter. They were approximately 13 and 11. They both were autistic and nonverbal, but you could see when you sat down and communicated with them and with their parents that they were clearly taking in more than you might think. They were having trouble being assessed because they were nonverbal, so that was a problem for the family. But they had never used the credits, and their household income, without going into all the details, that household didn't pay taxes. So I was able to get the kids approved and transfer the credits to the mother's mother, the maternal grandmother, and it could be transferred to her quite legitimately, because the criteria for the transfer of the disability credit is whether the person to whom it's being transferred assists the person with the disability with food or shelter or clothing to some extent, not completely. Of course, if they live with the parent, then obviously it would qualify. But it was clearly transferable because the grandmother did help her daughter and the grandchildren and the father because they had a very, very low income in the household. So we transferred it to the grandmother, and the recapture was $22,000 each, so $44,000. Plus the grandmother would continue to have her taxes reduced until the kids were 18 by about $2,200 a year per child. Plus we were then able to go back and capture the full amount of the Canada Disability Child Benefit for 10 years for both kids, for the mother in this case. So the recapture was approximately 5,000 times 10. Plus they would then go on to receive the Canada Disability Child Benefit of approximately $500 a month going forward until the kids turned 18. So you can see, you can understand that this is very gratifying work. I mean, the money's great. You know, it's so good to see the money. The client calls you just before Christmas and says, Ken, I just got $16,000 deposited into my bank account. And I say, isn't that just great? You know, it's very gratifying. And it's no more than what they should get. You know, all this is credits that they're supposed to use and haven't used, didn't know about. Somebody told them they couldn't use them. And we're putting them back in place. So it's a lot of fun, frankly. I have some questions here. Just give me a moment. Okay. Well, I'm going to touch briefly on the caregiver tax credit. No, I'll talk about RDSPs first, and then I'll go back to caregiver credit. If a person qualifies for the disability tax credit, they can then have a registered disability savings plan. Now, this plan belongs to the person who qualifies for the disability credit. So, even though the parent would often be what's called the account holder for the registered disability savings plan, it's not like it belongs to the parent and has been set up for the child the way an RESP does. It's not like that. And the RDSP is not like an RRSP in the sense that if you put money into it, you get a tax credit. It's not like that. It's a savings plan for the child, which is the child's property. And the trick is that if the child is, for example, 18, then based upon the child's household income, which is just ODSP, not the total household income, not the parent's income, then based upon the child's income on ODSP, then if you contribute $1,500 a year, the federal government puts in $4,500. I think that's a very worthwhile arrangement. If you happen to be one of the families we've assisted where we retroactively put the credit in place, RDSPs were first set up in December 2008, and it is possible retroactively to make contributions to contribute what you would have contributed from 2008 onward in the coming 4 years. So a retroactive payment in the next 4 years. And this would then result in the federal contributions that would have been received since 2008 being contributed in the next 4 years to the RDSP. And I don't have the numbers in front of me, but the last time I looked, what it means is that if you were to contribute in the next 4 years approximately $13,500, that the federal government contribution would be approximately $40,000. I'll give you the real numbers if you like. Just I have an attachment to send to you. But this is obviously a good thing if you can afford to do it. And of course, if we have just done a retroactive tax recapture and you have just received $16,000, then of course it's possible, if you wish, to make those retroactive payments. What I always advise people still is that if you don't wish to do that, that's perfectly fine, because if you contribute going forward for the next 20 years, which is the maximum period to make these contributions and get the matching money, you'll get it all anyway. So it's really just a question of, do you wish to make these retroactive payments excuse me, and then get a large lump sum, or do you wish to just make the payments going forward? Now that brings us to a question. If parents set up an RDSP, how does a will get set up in order for the RDSP to carry on? Well, the RDSP belongs to the child, so it carries on regardless. And even if you make no contributions going forward, the child will still receive at least every year the $1,000 bond. You don't have to contribute for the child to get the $1,000 bond, but to get the other $3,500, you have to contribute $1,500. And you could certainly make some specific provision in the will to have those contributions made, but that's unlikely. What would normally happen is the parents have passed on, but of course it's desirable to continue to make these contributions. So of course the child's trust would make them. The trust, which is set up once the estate is settled, with the share of the estate that is the child's to be held by the Henson Trust, well, that trust can certainly make these contributions, because all it's doing is it's making a payment, a disbursement out of the trust and into the child's savings plan. And then from there you get into the question of what about the child's will? Now, if you set up an RDSP when the child's 18, and you make the contributions for 20 years, so you've contributed 30,000 and the government's put in 90, then if it was invested at 5%, which is quite feasible, at 5% at the end of the 20 years, the plan is about 200,000. And then if it stays in there, and if you make no further contributions, and it stays invested at 5%, then when the child turns 60, which is the time that the child is normally free to start to access the money, it's a kind of a retirement plan. At that time, it's approaching $500,000, which is a lot of money. Now, granted, it's $500,000 in today's dollars decades from now, so it's not worth as much. I can appreciate that. But it's still going to be a sizable amount of money. It's going to be a lot, for example, the $500,000 is going to be more at age 60 for that child than quite often the other siblings. They're not going to have $500,000. I mean, maybe they will. But I think it's very fascinating, because we have a scenario now where we have kids with disabilities, special needs, but only the ones who qualify for the disability credit, not all the others who are on ODSP, who have approximately $500,000. Now, what happens if they die? Well, if they have gone past the 20 years of contributions plus a further 10-year waiting period so that the federal contributions have vested, so start at 18, 28, 38, 48, then at that point, say at age 49, the total amount would have vested. So if the child then passes on, he should have a will. Now, by definition, all of these kids qualify for the disability tax credit. So it's a reasonable presumption that a lot of them are cognitively impaired and are not competent to do wills. So what would happen is the child would die intestate, meaning no will. Testamentary, intestacy. And at that point, someone would have to apply to the court to make a probate application, to apply to become the administrator of their estate, which is basically their estate is the RDSP, without a will. Now, a probate application for an intestacy is not unusual. I've got two going right now. So it's not unusual. Slightly more complicated perhaps than a standard application with a will. You have to deal with the question of who is it that's going to step forward? Would you have to probate a bond? Or sort of have to have a bond to get probate. So certain issues you have to deal with. But someone is appointed, a certificate of appointment is issued. They can then go and access or pick up the RDSP, wherever it is. So the question then is, who gets it? Well, by succession law, there's a whole succession law tree. If the child has predeceased parents, well, then the parents would inherit it. We had one file like that last year, where the child was in his 30s and he died, and the vesting period had not passed, so that all that was to be recaptured was the contributions that the mother had made, and she was able to get those monies, in this case, without a probate application, because the contributions were still quite modest. There's ways around that. If the parents had passed on, then it would be siblings. But increasingly, there are no siblings in a lot of families. Beyond that, you would be looking perhaps at other family members, obviously, up the line, aunts and uncles, cousins. There's a tree that you can look at. And the part that I find interesting is that it's not at all impossible that if there's no siblings, that the parties that would, by succession law, would inherit would be cousins. And it may well be that the cousins, maybe they know of this person, this child, but they may have had nothing to do with them, and yet they're the ones that stand to inherit. And if the child, for example, was cognitively impaired and was in fully supported living situation, then their need for the $500,000 to draw upon it would be, very, very modest. So it would continue to grow. Say they're 60, now they're 80, and they pass on. So it's going to be more than $500,000. And you also get back, to take one step back, under the present RDSP arrangements, the child who is not capable, who's not competent, can't sign powers of attorney. And at present, only a parent or the spouse of the person with disabilities, which is not common, can be the account holder for the RDSP. Public guardian and trustee can also be an account holder. I had an inquiry the other day from a sporting organization who would like to set up RDSPs for a couple of their client people. But of course, the organization, the sporting organization that provides shelter and care and so on, the organization can't be an account holder. And in fact, there might even be a conflict of interest for them to be an account holder of this main asset for this person, while on the other hand, they're also compensated for their care. I don't know, is that less than arm's length? Is that too close for comfort? But they can't do it anyway. So what happens is someone has to apply to become the legal guardian of the child, guardian of their property and their person, which is a court application process. There's legal fees, there's competency assessment fees. It's not a cheap process. But because the person is alive but not competent, in order for them to have and to add to the RDSP, somebody has to be their legal guardian. Now, when the person dies, back to intestacy, when the person dies, the guardianship ceases. It's not like the person dies, the guardianship continues, and now they can settle their estate. It doesn't work that way. It's like powers of attorney, because of course powers of attorney are only effective while you're alive. If there's any questions about that, let me know. Question, can a successor make a contribution for the disabled child? The answer is yes. Technically, the child is supposed to consent to the contributions. And that may be problematic in some cases. What that'll come down to is how does the bank, the institution, the investment house, how do they respond to the fact that for example, that a sibling, parents are gone, sibling wants to contribute, how do they respond? Do they feel that the person the RDSP belongs to, that they in fact do have to contribute? Sorry, consent? Question, can the parents or family use the disability credit if the child moves out into a group home? The answer is yes. It's very commonly the case that the credit, that the family ceases using the credit when the child moves into supported living, because they have perhaps been told that the child has to live with them, but that's not true. The transferability is based upon food, shelter, or clothing to some extent. And although when a child's in a group home, they often would not pay rent, they wouldn't help with rent, they would often buy clothes, and it wouldn't be uncommon for the child to come home regularly, periodically, and at that point the parents maintain a bedroom for them, they feed them, they may prepare food to send back with them, so under those circumstances the credit is still transferable. This is a very common point of confusion.
Also retroactively.
And retroactively. Do you recommend more than one trustee be appointed to oversee a Henson Trust in order to support the deceased parent's wishes? If there is more than one person available as a trustee, then yes. If you have that great luxury of having the potential for multiple trustees, and if they get along, and considering that you need somebody who can be the trustee now if the parents pass on, and yet also be the trustee who is closer to the age of the beneficiary, because it wouldn't be uncommon for an initial trustee to be, for example, an aunt or an uncle. Well, of course, their age is similar to the parent, who's now deceased. So then you look at cousins, who might be of a similar age to the child, the beneficiary of the trust. And you then have to look at their compatibility with the beneficiary, their inclination to have this involvement in this supporting role. What I do is that, because you often can't think of who would be that successor trustee that is of a similar age to the beneficiary, what I do, and I've only seen this provision in one or two other wills. I review lots of wills. People send me wills all the time to check over. So I get to see, what other people are doing. Is I put a provision in where the last trustee of the trust can replace themselves. And they can either do this while alive to replace themselves, or upon their death. If they have a provision in their will, if I should die, the trustee of any undistributed trust, meaning that the beneficiary is still alive and that the residue of the trust is undistributed and not given to whomever gets it when that beneficiary dies. If I should die, the trustee of any undistributed trust, I appoint so-and-so. Because otherwise, what are you going to do? You have to give this authority to somebody, and of course the parents are gone. So I think this is a good procedure. Should I leave my life insurance, pension plans, RRSPs 100% to my estate? A financial advisor advised me not to. Well, firstly, the reason that the financial advisor says don't leave it all to your estate is to try to save on probate fees. And a lot of people have a mistaken impression about what probate fees are. Probate fees, there are no death taxes in Canada. There are probate fees, which is the filing fee based upon the value of your estate to apply for probate. And what it is 1.5% of the value of your estate. So on $1 million, it's $15,000. So you can see that if you're going to die with $1 million, $15,000 is a relatively small amount. If you can avoid paying it, excellent. But what happens is that people get into probate avoidance or probate fee avoidance, and they find what they don't realize is that this is going to actually complicate the settling of their estate in the way that they desire. And it may well be not the most tax efficient way to do it. So the question of should you leave it all to your estate, that's a question, a discussion to have with your lawyer to see how you should best leave your estate in order to distribute it the way you want it to be distributed. I'm going to touch on the caregiver credit now. Caregiver credit applies to the parent or to a sibling, perhaps, if the kid with disabilities lives with them. So if the child is at home and is over 18 and has a disability and is dependent to some extent, and if their income is less than $14,000, 14 to 18, then the parent, in this case, qualifies to use the caregiver tax credit. And if the child was, for example, 28, then you could backfile it for 10 years, and the recapture for most of those years is approximately $600 a year, but it's been recently increased the last couple of years to about $1,000. So you're looking at $7,000 or $8,000, and it would be very common for us to do a disability tax credit recapture plus a caregiver credit recapture, and so it would be roughly $16,000 plus, say, $8,000. Very common. But the child has to reside with you. And in those limited situations where you happen to reside with them, say they have a wheelchair accessible house or accommodations, and 1 year you go to live with them to help support them, that doesn't qualify. They have to reside with you. Okay, a mother set up an RESP when a baby was 6 weeks old. A baby cannot go to school as a result of a disability. Mom transferred some funds to an RDSP. However, mom is restricted to how much can be transferred. Well, I don't think that's correct. Mom is told there is no way to access remaining funds, some being her contributions, some grant. Well, it's true, she would lose the grants. But we have situations where an RESP was set up, and then at some point it may have been decided that the RESP was not going to be useful, and so the desire was to take the money out of the RRSP and put it into an RDSP. Well, obviously you can do that. The RESP belongs to the parent. It's their property. They can have the money back. So if they want to collapse it and take the money back, they do it. And of course there will be some interest income to declare. And of course the federal contributions will be clawed back, obviously, but that's about it. Does an agent, excuse me, does an agency or group home have a right to access information about a trust that has been set up for a child? No, they have no right at all. The trust will be a testamentary trust, or perhaps an inter vivos trust set up while alive. There's not a lot of those, but there are some. So it's normally a testamentary trust, meaning set up from a will. Why would an agency or group home have any right to access any information about such a trust? They don't, period. Period. And especially with respect to a Henson Trust, if it wasn't a Henson Trust and it had been set up incorrectly such that it was supposed to provide support for the child, in some way that was drafted incorrectly, well, then it could affect ODSP, it could affect shelter, that kind of thing, geared to income. That's very uncommon. I don't know if I've ever really seen that. It could be done incorrectly. But if it's a Henson Trust, there are two critical aspects to a Henson Trust. There are some other aspects that make it unique, but the first one is that unlike a normal trust, the trustee of a Henson Trust has an absolute and unfettered discretion. The trustee of a normal trust, a standard discretionary trust, not an absolute discretionary trust. The trustee of a discretionary trust has discretion to receive an estate and to invest the money and to disperse it in some way that they think is appropriate. But they could be compelled to provide support for the child because it's purely discretionary. They have to exercise the discretion. They can't fail to exercise the discretion. To give out nothing is probably not exercising the discretion. Now, of course, it's easy to get around this problem because all you have to do is make some kind of reasonable discretionary disbursement, right? That's just not complicated. However, those disbursements would affect ODSP. With the Henson Trust, the trustee has what's called an absolute and unfettered discretion. And if you have a will and you want to see if you think you have a Henson Trust, look for the words absolute and unfettered discretion. And then the second essential element, in a standard trust, the trustee holds the trust asset. Legally speaking, they hold the trust asset, but beneficially it belongs to the trustee. So the beneficiary. Beneficially it belongs to the beneficiary. So, for example, if you were to transfer your house into my name in trust, it wouldn't be my house. I would not own it. I would be the trustee. I'd be the title holder on title. If you did a sub-search, you'd find me. But it's not my house. I hold it for you. So you clearly have the beneficial interest in this house, which happens to be in my name. And that's the way a normal trust works. However, for a Henson Trust, there's a specific non-vesting clause. No share of the income or capital thereof shall vest in my said son, and the only interest he shall have shall be the amounts actually paid to him or for his benefit. So you can see that the asset of the trust doesn't vest in the beneficiary. They have no legal right to it. It's there to help provide for them, subject to the absolute discretion of the trustee. But it's not beneficially theirs. One day, when they're gone, when they die, the trust residue goes to somebody. Quite often, of course, it goes to the siblings. Could well go to any family members. It might go to charity, but it is not the property of the beneficiary. And so how could a judge award it to the beneficiary? How could the beneficiary successfully seek access to have this money given to them? Because it's not theirs. So some trustees are unwilling to provide funds from the trust to benefit the individual. Instead, the trustee is focused on protecting the asset. Well, firstly, what this does is it highlights the fact that you have to decide who your trustee is going to be and whether you need more than one, because one might have an abundance of caution, shall we say, and be somewhat, tight as far as the amount of money dispersed for the beneficiary. We have situations, it's not common, but we have situations where the trustee is the wrong trustee. And we've got a number of situations where it's a sibling, and the parents knew that the siblings didn't get along. They might both be, for example, adopted, never did get along, or one of them, the one who's the trustee, she married this guy, and of course, he influences her as trustee because, of course, the residue of the trust, when the beneficiary dies, would quite typically go to the sibling, the surviving sibling. Now, obviously, this is a potential conflict of interest, so you have to have that discussion with the parents every time. Is this a question where the sister, who would be the trustee, would be less likely to disperse money because if the sister, the beneficiary, dies, then she gets what's left? Well, realistically, this isn't a very common problem, a common issue. Typically, of course, the sister, the brothers, they've been raised all their lives with this child with special needs. They're quite, the issue of them withholding money for their own advantage one day is really just not likely, but it's an issue. You have to address it, and it does occur, no question. I've got several files like that right now. And when it comes right down to it, what you need to know is that if you come to me saying, my mom died, my sister is the trustee of a Henson Trust, we take a look at the will, yes, it's a Henson Trust. She doesn't give me anything, or she only gives me $500 a month, which is, on the face of it, the allowed amount, $6,000 over 12 months from any source. She only gives me $500 a month. I need more. I have costs that are related to my illness. I'd like her to give money for that. She won't do it. There's no hope. There's simply no hope. The idea of making the trustee disperse more money just isn't happening. Now, I would initially speak with the trustee and see if they realize that there are lots of options around, and instead of the $500 a month, $6,000 over 12 months, because it may be that that they think that is the only rule and that's all they can do. But if the trustee is simply not prepared for some reason to disperse money, there's no way to force them. It's just not happening. And of course, that's the one reason that that ODSP is not cut off, because the beneficiary of the trust can't compel the trustee to support them. That was the whole point. ODSP says, well, have Audrey's trustee provide for her, and then come back when it's all gone. Well, Audrey can't compel the trustee to support her, and that's why she was not cut off ODSP after the tribunal hearing and after the court case, because she can't compel the trustee to support her. So it's 11 o'clock. We're doing pretty well, I think, here. Do you know the status of proposed changes in legislation that would allow agencies to open RDSPs on behalf of individuals living in group homes who are unable to manage finances? No, I don't. Those agencies can't become legal guardians. That's a common question. It has to be a person who's a legal guardian or a parent under the present regulations, or the public guardian. You could get the public guardian to become the guardian of property for the child, adult. If there is a basic level of competence, you could have powers of attorney, but it wouldn't be appropriate to grant those powers of attorney to someone who is an employee of an agency. That's not sufficiently arm's length. And so here what we're getting into is a practical, tactical problem. What do we do, how do we do it to see that these RDSPs, which are such an important financial opportunity, how do we see that these individuals can access them, can get one? And it's just a real practical problem. We're now going to be getting into more estate planning. One thing that you should be aware of with respect to RRSPs and RDSPs is that it's possible to contribute an RRSP, which has been left to a child, to the RDSP. And the RDSP can have maximum contributions of up to $200,000. And of course, depending upon the fact situation, you'd want $30,000 of space to be available to make contributions to get the matching funds. But it wouldn't be uncommon for us to find a scenario where the child is over 49. They would qualify for, or they could have an RDSP. They don't have one, and they're over 49. So you can contribute to it until they're 59, but there's no matching federal money after 49. But in that window, that 10-year window, we have people who come into money in various ways. Personal injury settlements, inheritances, divorces, windfalls, and we need to exempt that money from the ODSP asset test, which we do quite regularly. And you can contribute up to $200,000 to an RDSP. So in that window period, the 49 to 59, wouldn't be unusual for us to set up an RDSP and then to exempt this asset that's coming from some source into the RDSP so that it doesn't disqualify the person from ODSP. We have a couple of other methods as well. If you happen to know anybody who is in the middle of a personal injury settlement and they're going to come into, let's say, $400,000, of course the $400,000 isn't really enough to carry on forever. It's not really, frankly, it's not a lot of money, especially for somebody who is getting the $400,000 because they've been injured. So we need to exempt the money, and it's quite common for us to exempt, let's say, $100,000, $200,000, $300,000, $400,000, so that ODSP is not cut off. It wouldn't be uncommon in a personal injury situation for somebody to be in a car accident, crossing an intersection, gets hit by a car. They already have certain disabilities and now they're injured. So they're going to come into $300,000 6 years later. And so they've been, working forward. One day finally there's a settlement, and then they realize, oh, that'll disqualify me from ODSP, which I've been receiving for 6 years, which I need because I had it before. Plus, because of the injuries, I need certain assistive devices or I have medical expenses that are very high. I can't afford to lose this. So that's when we get called. It's just about the time that there's a proposed settlement and they realize that they don't quite know what the heck to do with it. Some family doctors are reluctant to fill out the disability tax credit forms for autistic kids that are high functioning because of terminologies such as markedly restricted. Should I get another doctor to complete the disability tax credit paperwork? Well, yes, that's certainly one answer, and it's not unusual to have to do that. And you know, we still have situations where some elderly doctors, you know, they're just not current, and they think that in order for you to qualify for the disability credit, they have to be in a wheelchair, which of course is not true. Things have evolved quite a lot in the last 10 or 15 years as far as who would be approved. Now, what we would do in a problematic disability tax credit, a T2201 form, T2201, we get a T1013 signed, which allows us to represent the client. And then we need a doctor to complete a T2201. And what we would do, if we think that the doctor doesn't quite understand and might be hesitant to mark, you know, markedly restricted, aside from situations where, in fact, the kid is not markedly restricted. I had a consult with a client family yesterday, and the son, when he's at home, he has his own little bachelor unit. He's very reclusive, he's paranoid, but he does have a job at a library. And he does the job at the library. He's been there for a number of years. He just keeps to himself and does his job, right? When he's at home, of course, he has no friends. He's both paranoid and probably autistic. His only friends are his parents. And when he's at home, of course, he's reclusive, talks to no one, doesn't answer the phone, doesn't go out. And at work, he performs the work. The fear that the parents have is that this job has been accommodating. If he loses this job, can he get another? He's not on ODSP. He's working. He could be on ODSP, it's possible. Because the question is to qualify for ODSP, there's 3 tests. You can't function in a competitive workplace, you can't function in the community, or you can't handle personal care, or some degree of those 3. Well, in his case, he can't function in the community, or he doesn't function in the community. Now, the doctor may not know that. And as far as a competitive workplace, he can work in the library. Is that a competitive workplace? I'm not sure. So the question on the part of the parents is, could we get him approved for ODSP? Well, maybe. What about the disability tax credit? Well, that's harder. He's working. He pays his bills, gets back and forth from work to home. When he's home, he secludes himself. Okay. Does that mean he's markedly restricted? If you're a hermit, basically if you're an urban hermit, does that make you markedly restricted? Maybe. So you have to look at what's the likelihood of actually qualifying for these things. And then you have to dig into it. You have to talk to the parents and get anecdotal evidence, anecdotal information of the stuff that the parents know that nobody else knows. The extent to which that child, that person, couldn't stay in their own apartment if it weren't for all the adaptive, supportive things that the family does. Everything's been set up to be prepaid. Anytime there's an issue with something, the toilet needs fixing, you know, dad sees that it gets fixed, whatever it is. So the question I have in those cases is, you know, if you set up an apartment for this child and you just move them into the apartment, how long would they stay? How long could they cope on their own? And it wouldn't be uncommon to have the anecdotal evidence to then provide this to the doctor so that they have a much better idea of the real scenario. For example, I have a client, she moved from Brampton to Simcoe because Simcoe is closer to St. Thomas, and she has a brother in St. Thomas. But of course she kept the same doctor. Now, because of course, you know, it's pretty tough to replace a doctor. You move from Brampton, move to Simcoe, you're going to get another doctor in Simcoe, you know, tomorrow? Not likely. So of course you keep the same doctor. Now she has mental health problems, and she sees the doctor regularly. But what happens, of course, is that when she's having a bad time and she has an appointment to see the doctor, these days she doesn't go. And it's not that she can't drive, it's that she wants to present herself as well to the doctor. And a lot of the time she is well, but a lot of the time she's not. That's why she moved closer to her brother, so that when she's not well, if needed, he can come and see that she's okay and is provided for, and that she has food and the bills are paid. Well, if on a regular basis you need to live close to somebody so that, because you know, you have insight into your circumstances. You know that you need somebody close by regularly. You don't know when, but you do. Well, the doctor may well not know that. So of course when you ask them to complete the T2201, they're hesitant. Nothing that I see indicates that you're markedly restricted, they would say. So that's how I approach these more problematic T2201s. And sometimes you have to get the forms completed a couple of times. You'll find also that if the T2201 is submitted and it's really not likely to be adequate, don't submit it. You know, if you've prepared it and it's not likely to be successful, don't submit it. Because all you've done is, the first time around, you've provided the facts of the situation such that CRA doesn't approve you. And then the next time when you apply again, you have to say, oh no, it wasn't those facts as those were presented. It's these facts. It's like this. And that makes it quite a bit harder, actually. We've had to apply 2 or 3 times on occasion. Sometimes you have to work your way up the ladder, go from a GP to a specialist of some sort, get some new reports, new assessments. But of course, you can see that the disability credit is important, not just to transfer the credit to somebody to make use of it, but for an RDSP. So they kind of up the game as far as the disability credits are concerned. And it's very interesting. Last statistics I have were about a year ago, and they indicated that there are 82,000 RDSPs in place about a year ago. Now, if you have 600,000 people in Canada who are approved for the disability credit, I think 82,000 is probably a small number. And why is it such a small number? Well, there was a lot of fanfare in December '08 and early '09 when the banks started to provide RDSPs, but there hasn't been much advertising that I'm aware of really since then. And it's only the last couple of years that these plans have been available to be provided by financial advisors that aren't at a bank. The banks don't really promote RDSPs. Investors Group can provide RDSPs, Mackenzie Financial, Guardian Group of Funds. And investment houses that can sell mutual funds can provide RDSP instruments that are provided by, let's say, Mackenzie Financial. Meridian Credit Union, for example, is one of the few credit unions that can provide RDSPs. I've been working with Meridian the last little while to try to roll out seminars and information about RDSPs for Meridian. I'm generally supportive of credit unions, member-run organizations. And so I thought it was great when they started to be able to provide RDSPs earlier end of last year. Can a corporate trustee, which is named as a trustee for the trust, be allowed to make contributions to the RDSP as a successor account holder? Well, the corporate trustee can't be an account holder of the RDSP, but the corporate trustee certainly can contribute, $1,500 a year or whatever from the trust to the RDSP. There's no question about that. What happens if you have no one you trust enough to be a trustee? Well, that's a problem. I would say it's an increasing problem. Not so much that you don't trust someone. That's really not the issue. It's that you don't have anybody that you know well enough or who knows your child well enough to be the trustee. And if that's the case, then your best option is a corporate trustee. All of the trust companies will do a good job. There's no question. The trust companies are all managing large sums of money under management for trusts. The trust that I prefer is Concentra Trust. Concentra is the old co-op trust. And Co-op Trust, Concentra now, is owned by credit unions rather than banks and shareholders. And so the purpose of Concentra as a trust company is to provide services rather than to provide a service with an eye to making sure there's a profit for the shareholders. Concentra has to have a surplus, obviously. You can't run at a loss, but their trust fees are less because they don't have to pay shareholders, and they will take small trusts. So, for example, I met with a client couple yesterday, and the trust that is proposed for their one son eventually will have about $230,000. Well, $230,000 is a small trust. The concern that I have is that if I name another trust company without going through a process of getting them to say, yeah, we will accept such a small trust, which they won't, is that if you name them, that they'll decline. The client eventually passes on, the estate is settled. Now we're up to settling up the trust, and the trust company is notified of this, and they're just not interested. They might agree that if they had certain higher minimum fees that they would take the trust, but they're really not in that business. Concentra will take such a trust. Concentra does have certain minimum fees, but they're as competitive as they could be. And if your issue is you don't have anybody, I'm not sure what other choice you have. You could either have a trust company, or you could pick a professional. You could hire a professional. If the professional was prepared to be the trustee, you could get a lawyer to agree, or an accountant. A financial advisor, let's say you have a financial advisor that you're happy with. Well, it wouldn't be uncommon to think, oh, well, I'll have Joe, my financial advisor. He's doing a good job of handling the money right now, so I'll appoint him the trustee. I can't do that. Firstly, it's less than arm's length. The financial advisor could be a trustee, but they can't both be a trustee and the money manager. So they would have to give up the trust asset as something that they have under management. And they could do this. They could find a friend who's a financial advisor and have the assets of the trust put under management of this other advisor, and they would be the trustee. They would then receive trustees' compensation. Simplistically, a trustee's fees are 1.5% per year. So, on 100,000 or 200,000, you can see that it's not a great deal of money, and therefore not of much interest to trust companies. It might be sufficient to be of interest to a financial advisor. It's possible. But those are your options. We started an RDSP in 2008, when my son was 23. If we contribute for 20 years and wait the 10 years afterwards, can we start withdrawals at age 53? On the face of it, yes, you can. The money's all vested. There are certain formulas and circumstances to govern when you can take the money out and how much and so on. But yes, it's all vested. There are, of course, special provisions if the child happens to have life-threatening issues. That's already provided for. The original intent was that the money would be held until the child's 60, but you could access it after that. I have one or two families, not very many, who are concerned about the anticipated longevity of their child, and so what they've done is they've been making contributions, and either now or in the near future, whenever they appropriately decide, they'll stop in order to have the 10 years start to run, so that the vesting period is running. I am a retired educator. If I die and my wife is living, she gets 60% of my pension. If my wife dies, my disabled daughter gets, it says here, 60%. Can the 60% be folded into a Henson Trust so that ODSP is not affected? Well, I really appreciate that question, because that brings us to the topic of adult-dependent survivor pensions for kids with disabilities. If you are going to be a pensioner who will receive an OMERS pension, municipal employee pension, Ontario Power Generator Hydro pension, or teacher's pension, these are provincial statutory pensions. and it's similar in other provinces. The provincial statutory pension has a survivor pension for your adult dependent child. Now, this is largely unknown. People don't know about this. It doesn't matter, in my experience. You know, obviously, if you're a teacher, if you're a retired teacher, you're probably educated and intelligent. You know, you've paid attention to whatever you think you should pay attention to, as far as your estate arrangements and your, you know, death benefits and those kinds of things. But I would say that teachers, as a rule, who have kids with special needs, don't know that there is this adult-dependent survivor pension for their adult child. Period. And I find that they're very grateful to learn, because of course it's often a big piece of the estate planning puzzle. All of a sudden you're a retired teacher, you have a $60,000 pension, which is not uncommon. You die, your wife gets 60% of it. This indicates that the daughter will get 60%. It's my understanding that she gets 50%, but still. So let's say she gets $30,000. Well, it can't go into a Henson Trust. It's your daughter's pension. If she's not competent, then somebody has to be her legal guardian to set up this pension so she can receive it. If she's not competent, she can't do it. If she is competent, fine. She might need assistance, powers of attorney for somebody to help her to receive it and manage it. But she then would come into a $30,000 pension. And of course, if you have a $30,000 pension, you are disqualified from ODSP. That's how it works. I mean, we have people who are getting CPP disability, right? Well, of course, all the CPP disability does is offset ODSP, because CPP is, as far, you know, in my experience, is always less than ODSP, and simply offsets the 1,098. Now, of course, with this pension, with a teacher's pension, if the daughter financially no longer qualifies for ODSP, then on the face of it, she would also lose her drug and dental. And so there's the question of, well, how expensive is the drugs that she takes? Maybe they're quite expensive. So she would then have to get her medications under the Trillium program, which is income tested. If you have a situation, I have one very interesting situation where the mother, husband's deceased, she was a teacher, he was a civil servant. The civil servant's pension don't pass on. There are a couple of private pensions that can pass on. So if you happen to have a private pension, I'd like you to inquire of your pension plan. So for example, Aviva Insurance as one, and I think Bank of Nova Scotia, they have survivor pensions. So there is a pension for a survivor. And of course, what's contemplated is a surviving spouse. Well, what happens if you don't have a spouse, because you're divorced, or your spouse is deceased? Well, there's no survivor. Well, why shouldn't that pension pass on to your adult dependent child? And it can't. You have to make the request, because there is this pension that is planned. And I have situations where you take it to your HR people, your pension people, and you say, look, I have a daughter, a special needs daughter. My wife is deceased. When I die, will she get a pension? And that's what I want you to do. I want you to go to your pension plans, your HR people, and ask that question. And when you ask the question, just because the initial answer is no, don't take that no as the answer. Because in my experience, people will tell you things that they think are the correct answer, and people like to try to help, right? And so they try to give you an answer. Well, that doesn't mean the answer is correct. It may be the best answer they can think of. It may be the answer that they think is true. It doesn't mean that that is true. It's just what they think. So keep asking. Ask for it in writing. Send a letter, request a reply. And when you're content that there is no such pension, fine. But until you're content, just keep going. Quite often you won't find any reference to this on the website. You'll find a reference to dependent children, but not adult dependent children. You'll have dependent children, you'll have children who are still in school, but no reference on a website. You have to go to the manual, to the binder, the actual pension plan itself, to find out whether there is such a pension. And if there isn't, as I say, ask for it. Say, look, you know, I don't have a wife. I do have a daughter. She lives with me. I've been providing for her all her life, and I want her to have my survivor pension. Why not? At the very least, you'll raise awareness. It's going to be very interesting. Just as a child might have a sizable RDSP and be not competent, and you have to deal with these issues when they die, it's also quite possible that if the child is in, say, supported living, and now they have a $30,000 pension, that a sizable amount of that pension would accumulate for the next 20 years. And then one day when they die intestate, the sister, who is the legal guardian who's been administering this all these years, needs to apply to the court to be appointed the executor, and then by succession law she receives what's accumulated. And you know, just to give this all perspective, think of how many teachers there are out there. Think of how many municipal employees. I have no idea how many power generator or hydro workers, but they, for the most part, get good pensions. And if you die and nobody knows that this pension is available for your child, nobody applies for it, well, then they don't get it. With OMERS pensions, we have a minor problem, because the OMERS pension, initially to start with, might well be modest, might well be, let's just say, $1,000 a month. Well, if your son, who has a bipolar disorder and still lives with you and his sister at home, gets $500 a month as a result, well, of course, that $500 simply offsets ODSP. Doesn't do anything. And we had one situation down in Windsor some years ago, back in '01, and a father had died. He had an OMERS pension, and there was a son with disabilities and 4 daughters. And the one daughter, the daughters all helped to take care of the brother, and the one daughter heard about this pension. So she inquired further and then applied for the pension for her brother. Father had died 5 years before. The pension was $1,000 a month, which at that time was greater than ODSP, because it was $983, I think. So she applied for the pension for the brother. It paid for the 5 years retroactively, because he qualified, he just hadn't applied. So roughly $12,000 a year times 5, that's $60,000. So this was before I became involved with the family, and so this pension and this accumulated retroactive payment came to the attention of ODSP. I forget how. And of course ODSP looked into this, and The owner's pension is slightly greater than ODSP. And so ODSP said, well, that's our money. You know, we've been paying you $983 a month for these last 5 years, and you should have gotten, and you have now received, $1,000 a month for those 5 years. So that's us. You know, you owe us almost all of it. And that's right. That's correct. So from there, he was on a $1,000 a month pension, no drug and dental, and not an ODSP. Now, what I'm looking forward to in this type of scenario, and you have to fit into the scenario just at exactly the right time, is, especially with teachers, I want to make a deal depending upon the size of the pension. Let's say that the pension in an OMERS scenario was $500 a month. So all it does is offset ODSP. I would like to commute that pension to a lump sum, because I can exempt assets of up to $100,000, $200,000, $300,000, $400,000. So if I'm able to commute the $500 a month to a lump sum, something that is less than the actuaries calculate will be the total lifetime payment to that person, but a lump sum such that they don't get the $500 a month, which is of no advantage, I want to make that deal. It's kind of interesting, don't you think? I want to make that deal for $100,000, $200,000, $300,000 for whatever that amount is that is sufficiently less than the anticipated actuarial lifetime payments to that pensioner to be attractive to the actuaries for them to crystallize this unfunded liability, because I'm content that all of the actuaries of these plans have not planned for these pensions. It's not like, you know, if you have, in Ontario at least, if you have a pension and you then report that you have a child with disabilities and you've got a pension of $60,000, and now you say that you have a child with disabilities to get a pension when you're gone, your pension doesn't decrease. There's no actuarial calculations that I'm aware of where your $60,000 pension is decreased because now you're going to have a pension for your daughter. That's not how it works. And I'm content that these are unfunded liabilities. And I remember years ago, I talked to a couple of actuaries. I was talking to RTO, Retired Teachers of Ontario, about this. And I was talking to a couple of actuaries with the teacher's plan. And I said, well, how many of these, how many people are receiving such a pension now? And they said, oh, about 12, which could be true. But do you really think that of all the retired teachers in Ontario, only 12 have a kid with special needs? Obviously not. So firstly, you know, there's a whole lot of people who are pensioners now who don't know about this and need to know because it's part of their plan, should be part of their plan. But as well, all of these pensions should be put in place, and nobody knows about it. So it's going to be very interesting to see how teachers funds all these pensions. Our daughter has Fragile X, currently has the disability tax credit that will have to be updated this year with a T2201 as she is turning 19. Well, based upon her development, we may not qualify or meet the requirements for the disability credit going forward. She currently has an RDSP. What would happen to the RDSP if she no longer has a T2201? Well, if she does not qualify for the disability tax credit, she can't have an RDSP. So if she happens to already have one, she has, I believe, 3 years to be reapproved for the disability credit. But if she doesn't qualify after this period, then she has to give the federal money back and collapse the RDSP. The RDSP money is her money, so it would go to her. You then get into the fact that she has an asset which we need to exempt so that it doesn't disqualify her from ODSP because she's now 19. So it doesn't go back to the parents who have contributed it. And you're right, Fragile X, I could see that it's possible that she might not continue to qualify, but what you need to do is give some serious thought to making sure that that the next time that the T2201 is completed, that you have enough supporting information and documentation about her activities of daily living, that the doctor fills it out properly. So make sure you get the right doctor and that you've properly explained the restrictions that your daughter has, notwithstanding all the other good stuff that she does quite capably, because this is important. Now let's see what else we have to talk about here. Let's talk about RRSP rollovers. You can roll over an RRSP to an adult dependent child who has cognitive disabilities. Now, that's fine. The complication is that if you leave an RRSP to an adult dependent child who has cognitive disabilities, the people that you work with that have the RRSP, of course, aren't familiar with this process, but it certainly can roll over. But then the child, firstly, they have an asset, which the question is, can they manage it? You know, are they capable of managing an RRSP? But also now they have an asset, which of course means that they have more than the $5,000 asset test. So the asset could be received, but it would have to be exempted as an asset. Now, if it's less than $100,000, I can certainly exempt that. If it's greater than $100,000, it becomes more problematic. You could leave a larger RRSP, and the child could contribute it up to, say, $200,000 to their RDSP. If you needed to have the $30,000 contribution room, well then of course you can't contribute $200,000. You can only contribute $170,000. But if it was contributed, designated to the child, and then contributed to the RDSP, well, it's exempt as far as ODSP is concerned. Now, if it's larger, what you'd want to consider is what's called a lifetime benefits trust. It's a new type of a trust that is specifically and only designed to receive registered funds, only registered funds, and to have only one beneficiary. And it receives the money, and it then purchases what's called a qualifying trust annuity, which would be an annuity based upon the expected lifespan of the beneficiary of the trust, your child. And then these annuity payments are paid to the trust and then ultimately paid out to the beneficiary. And the advantage of this is that there's no limitation as to the size of the trust. It's clearly exempt because it's in a trust for the child. It's not in their own hands. It's not in their RDSP. And the trust provisions determine who gets what's left when the child dies. So, you know, if you leave an RRSP directly to a child or into an RDSP, it's their property, so they need a will. And they may or may not be competent to have a will. But if you leave the RRSP or the RIF to the Lifetime Benefits Trust, which is a parallel trust in your will, parallel to the Henson Trust, then you get to decide where what's left goes. And there's no need to deal with competency issues of the child while alive or intestacy. In the sense of funding an estate, I'd like to speak briefly about life insurance. Life insurance is often the cheapest way to create an estate. And if you consider, for example, a joint and last policy, say there's a mother and a father, and you insure both lives, but the insurance pays on the second death. So joint and last. Similarly, you could have joint and first, and of course you can have individual lives, but if you had joint and last, and if you had a T100 or a term to 100 policy, a whole life of some sort perhaps, then there's a fixed premium. If it's a term to 100, meaning it's a term policy, but term to age 100, which I think is going to cover most of us, then the policy premium is fixed. And it's typically fixed until the second death. You can have it such that it's a fixed premium and the premiums cease on the first death. You can do that. Of course, the premium will be higher. But what it means is that upon the first death, although there's no insurance payout, there's no more premiums. And then on the second death, there's a payout. And what you would do is you would typically designate this insurance payout to the trust for the child. So what this means is that even if you use up your total estate for yourself because you're, in a care home, or your estate is modest because it's divided by 5 children, and you leave an equal share to each child because you love them all equally. Well, what that means is that the share to the trust for the child with special needs is also a small amount. Well, you can supplement that quite economically with a joint and last T100 policy. So, for example, a male, these are just sample numbers, I'll get you real numbers if you want, but non-smokers, male 55, female 50, approximately $1,000 a year could pay $100,000 on death, on the second death. So what that means is that if you tried to save $1,000 a year in order to have $100,000 on the second death, you'd have to save it for 100 years. Now obviously, if you have a male 55, female 50, the female, who's younger, is not going to live for 100 years. So if your desired return on investment, if you want to make such a calculation or get your financial advisor to make such a calculation for you, it's easily done. I have an actuarial table. I can tell you from McCullers structured settlement how long you're going to live. And the interesting part is that I can tell you how long you're going to live, and then when I scroll down to that age, it turns out that if you're still alive, you've still got another 6 years. It's very interesting. But what it comes down to is that one of the most economical ways to create an estate or to fund the trust is to have for example, a T100 joint and last policy. It's designated directly to the trust, doesn't pass through the estate, so it's not subject to probate or any claims against the estate. It's paid quite quickly, and the advantage of this is that if you happen to have a scenario where, in fact, the parents or the surviving parent are actually supplementing and providing for the child on an ongoing daily, weekly, monthly basis, such that if they were out of the picture, there would be weekly, daily, monthly expenses or financial supports that are not being met. Well, if you have insurance, it typically pays very quickly. If the trustee of the trust knows that there's the policy and they've got a photocopy of the policy, then all they have to do is submit a proof of death to the insurance company and get an insurance claim form and have it completed and then submitted. And typically within something like 30 days at the worst, there's a payout. And it would be paid directly to the trustee. So in a relatively short period of time, there's a chunk of money that is available to continue to provide support for that particular child. And if anybody's, I find it fascinating actually, the fact that it's much more economical to give your money to an insurance company than it is to put it into some investment that is separate and earmarked for the child, which is subject to probate, and whatever income that is generated from it is taxed in your hands all those years. It's just a real uphill battle to fund a trust that way. Are there any other questions? No? Okay. It says are there ways to exempt assets other than RDSPs? Well, yes, there are. There are a couple of ways. If you are going to receive an inheritance outside of a will, or like a life insurance directly, or through a will which has no Henson Trust, then I can exempt up to $100,000 that flows from a death. And the bigger part of my estate work is not so much my clients who die, because of course their affairs are all in order. For them we apply for probate and then help to settle up the estate and then set up the trust, and it's all pretty standard stuff. It's all the other people who are not my clients when they die, who leave money for their kid with disabilities, and I'm then contacted by either them, the child, which is not typically the child, but sometimes, or by their brother or the executor, and says, well, Mom died 3 months ago, and now we're settling up things, and there's this initial check for $6,500 that's going out to everybody because there was a bank account with $50,000 in it. What am I going to do? This check will disqualify my sister from ODSP. So that's a very common scenario. I would say that happens twice a week. There's about 250,000 people in Ontario on ODSP. This doesn't include the people under 18 or over 65. And if you look at those numbers, that's about a third again. So if there's 250, then there's, let's say, another 80,000 that are either over 65 or under 18. Under 18, you're not in those numbers because you're not receiving ODSP. If you're over 65, again, you were receiving ODSP, but now you're receiving old age security and guaranteed income supplement. And if you did work at some point, then perhaps some CPP. The old age security and the income supplement is about $13,000. So it's roughly the same as ODSP. And the drugs would be covered under the Ontario Drug Benefit Program. So it's very similar support-wise. but those numbers are not included in the 250. And if you do the calculations, what it comes down to in each of the, I've got all the statistics for all of the different communities, and if you'd like, I'll send them to you. But just trust me here. If you do the calculations and you take a look at the community and you divide the population of the community by 3, StatsCan says that if you divide the population by 3, that'll tell you approximately how many households there are. So in Ottawa, for example, population 900,000, there's about 300,000 households. And the numbers are higher now, but as of a few years ago, there were 15,000 people on ODSP. There's presently, I think, 21,000. But for simplicity, for the calculation, if there's 300,000 households and there's 15,000 people, adults, on ODSP, and if you don't calculate their household as part of these numbers, if you presume that there's 15,000 parent households for the 15,000 people on ODSP, and maybe the people live at home, but regardless, that there's 15,000 parent households, and that they have only one brother or one sister. And of course, I'm the eldest of 5, but say there's only one sibling. That's another 15,000 households. And that's the sibling household that will be the trustee of the trust for that child with disabilities. That means that there's 15,000 parent households and 15,000 brother-sister households, 30,000 households of 300,000. So 1 in 10. 1 in 10 consistently is either the parent of or the brother and sister of a person with disabilities who's an adult on ODSP. And this is consistently the case. For example, I regularly make presentations to groups of financial advisors. And if you have a group of, say, 60 advisors, and I'm spending an hour or hour and a half explaining all this stuff from a financial advisor's perspective so that they can better serve the families, at the end of the time, it would consistently be the case that 6 would come up to talk to me separately, specifically. And they would identify themselves as either the parent of, the father of, mother of, or the brother of, sister of somebody with special needs. And it's consistently 1 in 10. And you'll find that in any group that you happen to take part in. If you're in a school meeting or some neighborhood organization or whatever, very, very consistently, 1 family in 10 is the parent of or the sibling of a person with special needs. And of course that doesn't include the families who have kids under 18 or where the child is 65 and older. So now they're a senior. And I think it's fascinating that if those are the numbers, and in some of these communities, like for example Sudbury, it's 1 in 5. I was just up there last October. I'd been invited to speak to the Sudbury Law Association. They had a symposium, annual event, and so I had a really nice time. Sudbury is a nice place, and you can fly there. The airport to get from downtown in Sudbury to get to the airport is $80 by cab, because it's removed from the downtown. And Sudbury is a very large municipality. It's got something like 230 lakes within the municipality. So just about everybody has a house with a waterfront. And of course now they have an architecture school and medical school and a university and a nice big hospital and a children's treatment center. So, Sudbury's really grown in the last 10 years. But because Sudbury is a catchment area, right? If you're in Kapuskasing and you need something, you're going to go to the hospital in Sudbury. Now, there is a children's treatment center in, where is it, north of Sudbury? I was there a few years ago. I forget, but there is a nice small new children's treatment center, about an hour and a half north of Sudbury. But for the most part, if you need services, you have to go to Sudbury or Toronto. And so in Sudbury and also in Cornwall and in Brantford, the numbers are significantly higher. Cornwall and Brantford, it's not so much that it's a catchment area and everybody has to go there. It's that a couple of decades ago, they deindustrialized, and a lot of able-bodied people left, and the people that remained were people on pensions. We're getting close to the end of what I have to say. If you have any final questions to send me, I'd appreciate it. Thank you. Says, how long is ODSP valid? ODSP runs until you're 65, and then you're a senior, and you apply for old age security and guaranteed income supplement. And then at that point, a common question is, well, can we just collapse the trust? You could. A Henson trust can certainly be collapsed. But again, you'd get into the question of, would it be appropriate to give the trust asset to the beneficiary? Could they manage it? Would they lose it? Would they all of a sudden get a bunch of new friends? These are just realistic questions. And also, the taxation of trusts. I guess I better touch on that. Taxation of testamentary trusts. There are new rules as of 2016. Under the old rules, a testamentary trust that declared trust income in its own hands would pay tax on the first $40,000, just like a person, at 22%. So from an income splitting perspective, testamentary trusts were very, very helpful. You could, for example, be a person with no disabilities, and just to touch on that, Henson trusts are not just for people with disabilities. Trusts are useful for other people, many people who don't have disabilities, to protect an inheritance from litigation or from divorce or from any kind of claim. And also they can be very efficient. For example, if your sister has special needs and there's a Henson trust for her, okay, your parents pass on, the last of your parents die, and there's an estate to be divided, and you're going to get the same amount as your sister with special needs. So the trust is set up for her, and that's all good. Well, what about your share? Well, if there was a trust for you, for your share, and it would be a Henson trust, because it's very powerful, it's the most protective, most powerful type of trust, then your share would be received by you as a trustee of the Henson trust for you and your children. So you'd be a beneficiary of the trust, just like your two kids. So you inherit your $300,000. It's received as a trust. You invest it at, say, 5%. it generates $15,000 of income. Now normally if you had received that $300,000 personally and you had invested it at 5%, you would have $15,000 of income, which you would declare at your rate. And if you were earning up to $80,000 a year, you'd pay tax at 33%. And if you were earning more than $80,000, or if the trust income put you over $80,000, you'd be paying tax at 44%. So instead what you do is you receive it as an inherited trust asset, a Henson Trust, and you're the trustee and you're a beneficiary along with your 2 kids. So if you wanted to access this trust asset, you could just go take it. But otherwise you invest it, it generates $15,000 of trust income, which you then declare in the hands of the children. So you attribute $7,500 to each of them, and they each have a personal tax credit of $11,000. So there's no tax. So you inherit an asset, you invest it, and up to, let's say, the first $22,000 of income is declared in the hands of the children, and therefore there's no tax payable. That's much better, because even if all you do is you save $5,000 a year, or 33% of $15,000 for, let's say, 10 years, well, that's $50,000. This is better. Not paying tax is better. And as well, that inherited asset, which is kept inside the trust, is not divisible if you divorce. And if that trust was used, for example, to buy a home, and you and your spouse live there, well, the trust owns it. So it's not a matrimonial home. It's not divisible. And in a matrimonial home, a spouse has a right of occupancy. So say you're gonna split up. You and your spouse are gonna split up. Well, you can't kick your wife or your husband out, because the spouse has a right of occupancy in a matrimonial home. If the trust is owned by if the home is owned by the trust, well, then you could evict them, because the trust could evict them. And so you can see also that say you wanted to buy a little condo for your child with special needs. Well, you could purchase it yourself, and you could keep it as a rental property, quotes. And then when you die, you're deemed to dispose of it, so the capital gain is taxable, plus it's part of your estate, so it's part of your probatable value. Well, what you would do, if you talked to me about it before you bought the place, is you would consider whether to set up an inter vivos trust while alive between living people, inter vivos, and this inter vivos trust, of which you would be the settlor and trustee, would own the condo, and your daughter would live in it, and because the beneficiary of the trust resides in this property, the capital gains, principal residence capital gains exemption applies to the trust. So the capital gains are not taxable when you die, well, at any time, but also the trust does not belong, the asset does not belong to you. The asset, the home, belongs to the trust, which of course is not part of your estate, because it's an inter vivos trust. It's set up while you're alive. So that, similarly, this doesn't happen very commonly, but if you did buy such a property, it's protected, and even if your child should marry, and the spouse moves into this home owned by the trust, it's not a matrimonial home. I was talking to a client just the other day, and the daughter lives in a rental property with a small granny flat that is owned by the parents and in the name of the parents and 2 brothers. So to make a long story short, what the client wanted to know was whether they could transfer this property directly to the daughter. Well, you could. The problem would be that the rent paid for the granny flat, 60% of the rent would be offset against the daughter's ODSP. ODSP doesn't say, well, you know, okay, you've given us all of your shelter costs for this total building, and here's the amount that somebody else pays towards rent. So we're going to take that off, and then in calculating your shelter costs, we're going to take the remainder. They don't do that. They just take the rent that is paid and then take 60% of the rent and offset it against the ODSP of the other party, which of course is generally pretty onerous. What is the impact of student awards or bursaries for a student who is receiving ODSP and attending university? My understanding is that they're exempt. And my understanding also, I just dealt with this the other day, is that the income earned by a student is also not subject to the standard income and offsets that ODSP has at present, that the income is exempt too. You might want to look into that further. Is ODSP a one-time application for ongoing payments, or do you have to keep applying? No, it's a one-time thing. You want to make sure that the application is successful so that you don't have to go through a benefit appeal or apply again. But normally you apply once. Years ago, there used to be sort of random audits, but I don't see that anymore. And I was told, saw articles in the paper, that that ODSP was going to be doing a certain number of block group audits now, but I haven't heard anecdotally from any clients that they're being audited. So that's 1218. I think that unless there are any further questions, we'll just sort of wrap up. I want to thank Tony Goujon for introducing me and to being the supporting person for this. I'd like to thank Ontario Telemedicine Network for carrying the webcast. And I'd like to thank Christian Horizons Ottawa or Eastern District for allowing me to use their boardroom and their facilities to provide the webcast. People should feel free to send me emails or queries of questions that are follow-ups on this. This webcast will be archived on my website. Actually be on the OTN website, but I'll have a link on my website. So we'll send out the link and the passwords to all the people. I think I'll just send it out to my newsletter list. There's about 4,860 people on that, so I think I'll just send it to them. But we also have about 60 people who registered as not being able to take part today but wanting the link. And so of course we'll send that out to them specifically. Other than that, I'd like to thank you for taking part. I hope you found it educational, and thank you very much.